charge your battery.
Yes, Sir James. Before we start, may I simply address you, Mr. Hussain, and express the court's concern at hearing the news that Miss Blinini Harali, King's Counsel, has been taken unwell over the weekend. We wish her a speedy and full recovery.
My lady, that's extremely kind of you. Thank you very much.
Thank you. Yes, Sir James.
My lady, on this side of the court, we thoroughly join in with that sentiment.
Thank you.
My ladies, my lord, I appear on behalf of the Secretary of State with Mr. Blundell, Mr. Watson, Ms. Parsons, Mr. Cosmin, and Mr. Laird. And for the respondent, Ms. Ammori, Raza Hussain, Mr. Luckhurst, Mr. Greenhall, Ms. Morgan, Mr. James Matthews, Ms. Hamad, Mr. Fakouri, Miss Bergin, and Mr. Kynaston. Miss Negruli, we've already mentioned, who can't sadly be here. So that's the representation. My ladies, my lords, I hope that you got a recent email from us in relation to the bundling. As always happens when additions are made late, you get A, B's, C's, D's and E's, and what that does is to create a complete disconnect between the physical numbering and the electronic numbering. So I'm going to give you both, unless you tell me that's unnecessary and that you're all working electronically, in which case I know my Lord Master of the Rolls will be, but unless you tell me otherwise, in which case I'll just give you the E references.
I think a hybrid approach would be best. And thank you to everybody for the hard work that's gone in preparing for this week's hearing under time pressure, I know, and I know there's been a lot going on behind the scenes.
I think we're all very grateful for that. You should, by way of bundles, then have a core bundle, which has about 489 e-pages, 37 tabs.
Yes.
A first agreed supplementary bundle.
Yes.
34 tabs and 419 e-pages.
Yes.
An authorities bundle which runs, I'm afraid, to 3,221 e-pages.
Yes.
An ancillary bundle running to 153 e-pages, and what's called a second agreed supplementary bundle, 62 tabs, 1,196 e-pages. I will be referring, I think, almost exclusively to the, assuming that the court has had a chance to look at the core bundle and take some of those documents as read, I'm going to be referring exclusively to the authorities bundle and to the first agreed supplementary bundle. So those will be my sources of reference. So far as the timetable is concerned, the parties have agreed a timetable and a structure subject to the court's views.
Yeah, that looks sensible.
Of course, I'm grateful. I won't repeat it if you do have it already.
Yes.
I think
perhaps for members of the public, you'll be opening the appeal until approximately 3 o'clock this afternoon. Then Mr. Hussain and his colleagues will be responding to the appeal and opening on the cross appeal until, I think, approximately 2:30 tomorrow afternoon. You will then respond to the appeal, reply on the appeal, respond on the cross appeal between 2:30 and 4, and then Mr. Hussain will have the last word, replying on the cross appeal between 4 and 4:30 tomorrow afternoon.
I'm very grateful. And I should mention, there, I think it's proposed that there should be a closed
hearing tomorrow, Thursday morning.
On Thursday morning, Thursday.
Very early, yes.
So that's to be done. And one other thing to mention in relation to reporting restrictions, I've asked the clerks to put on your desk each a single page. I don't think you need to make a further order. I think this order is already in place, but you just need to be aware, perhaps the public do as well, that it is there.
Well, we're not actually, at first blush, and it is at first blush, not necessarily content with the terms of this order. When this order was made, it was before the publication of the Divisional Court judgment, for example, and we would need to be persuaded that we should not terminate this order, or that rather be persuaded the order should still be in place in the terms in which it appears at first blush. And I'm assuming members of the press have a copy of this order because they made representations at the time. 1C seems to be far too widely drawn. At least we would need to understand better what the justification was for maintaining this reporting restriction in these terms at this stage. So I'm sorry to be difficult,
Not at all, Madam.
but I think we will need some more background, taking into account events since this order was made before we, as it were, continue it. As you say, it's in place at the moment, strictly speaking. But I think we would like to revisit that, and perhaps with the ranks behind you, Sir James,
Can I do that?
somebody can have a think about that.
Is that possible? Then we can perhaps come back either later in the morning
Yeah,
or
thank
after
you.
the short adjournment. But for the moment, it still applies.
Thank you very much.
Thank you. We're going to split the advocacy on our side. I'm going to address everything apart from discrimination. Come to a bit later, which Mr. Watson is going to deal with, and then Mr. Blundell is going to assist you, if that's acceptable, on the closed hearing. That's how we're going to do. That's how we're going to do that. Ladies and Lords, by way of outline of the appeal, as you know, concerns a claim brought by Ms. Ammori, who is the co-founder of Palestine Action, challenging the lawfulness of the decision of the Secretary of State for the Home Department to proscribe Palestine Action. The decision was made on the 14th of May 2025 and was retaken on the 20th of June 2025 and was communicated to Parliament by way of a ministerial statement dated the 23rd of June 2025, which you have in the core bundle, physical page 137, electronic page 173. The claim also challenges the consequent Terrorism Act 2000 brackets Proscribed Organisations Amendment Order 2025. You have that order in the authorities bundle behind tab 7 if you're on bookmarks, page 216. Mercifully in the authorities bundle, the electronic and the physical numbering coincide. So I'm going to give you
So the order is challenged as well as the decision?
the order is, I think the order is challenged as well as the decision, yeah. That order came into force on the 5th of July 2025, and its effect was to amend Schedule 2 to the Terrorism Act 2000 to include Palestine Action in the list of proscribed terrorist organisations where it currently remains. There have been 2 prior visits to this court, as at least 3 of you will recall. First on the 4th of July, demonstrating how speedily the court can move when it wishes to, on an appeal brought against the decision of Mr. Justice Chamberlain of exactly the same date. I think you were troubled in the evening on that day in relation to whether interim relief ought to be granted prior to the prescription order taking effect at midnight that night. The judgment that the court gave on that occasion, or the judgments, the judgment of Mr. Justice Chamberlain on interim relief is in the authorities bundle at tab 45, if you want it, 1269 and following, and the Court of Appeal's judgment upholding Mr. Justice Chamberlain is in the next tab, tab 46 of the authorities bundle. That was the first occasion the court was troubled. The second occasion was in September on the question of whether or not POAC afforded an alternative remedy, an adequate alternative remedy. And alongside the determination of that appeal, with the court deciding that POAC did not provide an adequate remedy, so judicial review would proceed. Alongside that appeal, the Court of Appeal also extended the grant of permission to claim judicial review on 2 further grounds, which are now live before you, which were then, my Lord will recall, grounds 5 and 6. The judgment in that case was given on the 17th of October by the Court of Appeal, and you find that judgment in the core bundle, page 179, capital S for sugar, electronic page number in the core bundle 297. The substantive hearing of this claim then took place before the Divisional Court, comprising the President of the King's Bench Division, Mrs Justice Steyn and Mr Justice Swift on the 26th and 27th of November last year, and on the 2nd of December, I think there was a closed hearing, there were open and closed sessions therefore. They handed down their judgment on the 13th of February 2026. Their judgment from which this appeal proceeds is in the core bundle, pages 84 to 129 in the hard copy, electronic 97 to 142. And in broad summary in relation to the Divisional Court judgment, they dismissed the claim on ground 5, failure to consider relevant matters. See the judgment, paragraphs 68 to 71. They dismissed the claim in relation to ground 8, prior consultation. See paragraphs 47 to 67. And they dismissed it in relation to ground 2, insofar as a breach of Article 14 of the ECHR, that's discrimination, was alleged. See the judgment, paragraphs 143 to 145. The claim succeeded, however, on 2 grounds. The first of them was ground 6, which was a challenge based on the Secretary of State's policy. See the judgment 72 to 96, paragraph 72 to 96. And it succeeded on ground 2, which was the substantive ECHR challenge based on Articles 10 and 11 of the ECHR, that's freedom of speech and freedom of assembly. They decided against the government in relation to those matters on the prescribed by law ground. That was essentially parasitic on their finding in relation to the policy, and on the fair balance limb of the Bank Mellat test, which will be very familiar to the court, I know. Their judgment on that part of the case is between paragraphs 97 and 142. The Secretary of State then appealed that judgment on 2 grounds. The first appeal ground relates to what was ground 6, in other words, the policy ground. That is dealt with in our skeleton for the purpose of this appeal, the Court of Appeal skeleton, and I hope you've had a revised version of that with the,
yes,
with the twin references in.
Yes.
That's our skeleton, paragraphs 32 to 57 on the policy ground. And the second appeal ground challenged the decision on Articles 10 and 11. And in our skeleton, that is dealt with between 58 and 76. The claimant then cross-appealed in respect of the dismissal of ground 8, that was the prior consultation or prior representations point, and on the Article 14 point. By order of the 25th of February 2026, the Divisional Court granted the Secretary of State permission to appeal, refused permission to appeal to the claimants on their cross-appeal, and stayed the quashing of the decision pending determination of this appeal. So the effect of the Divisional Court's judgment is currently stayed pending consideration of the issues by this court. There was a renewal of the claimant's application for permission to cross-appeal by way of a respondent's notice, and the question of permission to cross-appeal is to be heard on a rolled-up basis pursuant to the order that my Lord made, on a rolled-up basis at this hearing. So we're all going to address the substance of those points, make mind up about permission or not, and substance or not, depending upon that. The application for permission to cross-appeal, if you want it, it is in the ancillary bundle, tab B1, B for Bertie 1, page 57. The court might also be interested to know that there are...
Proceedings in Scotland. Yes.
There are.
When is the hearing in
Well,
Scotland?
my lady, it is not quite clear, and it's not quite clear as yet whether there will be a hearing. What happened, as I understand, is that proceedings were issued, and there is a question at the moment about whether or not interim relief should be granted in those proceedings to, in effect, to suspend the operation of Palestine Action's proscription, which would obviously cut directly across the stay that the English Divisional Court made pending the consideration of this case in this court. and the powers that be, the government in Scotland, as it were, have made an application, or about to make an application, I think, in relation to the question whether or not that application, and indeed the proceedings themselves, ought to be stayed. So there is a potentially quite interesting question there about not so much jurisdiction, because I think everyone accepts that there is concurrent jurisdiction as between the courts of Scotland and England, and the same logic would apply in relation to Northern Ireland, where there's been, as I understand it, some sabre rattling in correspondence, but no formal application yet. But the question in relation to the cyst, that is the potential stay of the proceedings in Scotland at the behest of the government, raises questions about abuse and about spiliada and about correct forums and about what happens when you have precisely the same case at different stages in different courts of the United Kingdom. Of course, it has happened before, but very, very rarely, and mostly in terms of, in cases involving extreme urgency. I think it happened in the prorogation case, but those proceedings are currently live in Scotland.
And the Scottish courts have been made fully aware of this hearing? Yes, so as a matter of comity, there is full open communication.
There is, and that indeed, you won't be surprised to hear me say, is the basis on which the question about assisting the Scottish proceedings is being raised by the government, to avoid that thing where different courts of the United Kingdom reach different conclusions on the self-same issue, in effectively the self-same case.
It might be useful to know the dates of any hearings in Scotland, because that may or may not tie in with the date of any judgment in this.
Yes, my lord, I'll get them to you as soon as I know them. I'm not at the moment sure what the next scheduling date has been.
Yes.
I think at the moment there are a flurry of applications both way in relation to interim relief and the possibility of sisting, and I think the court may not have yet set a date for the determination and consideration of those issues. That at least is the position. I'm told that there is I think may have to be a provisional date, but there is at least a provisional date pending applications for interim relief and or applications for sisting. The substantive hearing is currently listed for 24-25 June, but it may be that drifts in the light of those interlocutory applications, which would obviously render that substantive hearing, at least one of them might render that substantive hearing unnecessary. Of course, the court will be very well aware that the Supreme Court recently considered, in the case called Janchuk, what weight ought to be given to courts of coordinate jurisdiction. So there was a Court of Appeal judgment in Northern Ireland on essentially similar issues to the issues that were then before the Court of Appeal in England, that then went to the Supreme Court, and there was a live question there which they've resolved about what degree of weight should be attached to a judgment of coordinate jurisdiction on the same or similar issue of principle. And the Supreme Court has laid down some guidance in relation to that, but this case obviously raises a rather more extreme and slightly different version of that sort of issue, because it's a self-same case, effectively.
But not an issue that needs to trouble us.
Not an
amongst
issue
the
that needs
many
to trouble you, but at least you ought to be aware of it. All I want to say by way of outline of the appeal.
Thank you.
I was going to turn to legislative context.
Yes.
Of course, lots of this I can take from the very helpful and detailed judgment of the Divisional Court, but legislative context is the next title. We've dealt with that in our skeleton at paragraphs 5 to 11. I just wanted to make 4 short points in relation to legislative context, taking the legislation itself as read. I know the court will be very familiar with quite a lot of it, and 3 of you having had to consider it on the other applications that I mentioned earlier. But the first point I wanted to make was that the general purpose of the Terrorism Act 2000 has recently been considered and been the subject of some comment by the Supreme Court in the ABJ case. If you have your authorities bundle, please, you go to tab 49, if you bookmark in the physical, it's page 1785. It starts see it's a unanimous judgment of the Supreme Court given 26th of February of this year read giving the judgment of the court effectively. He was joined by Lord Sales, Lord Lloyd-Jones, Lord Burrows and Lord Richards. And you see the nature of the issue at paragraph 1. I'm going to go back to this case on a couple of occasions during my submission. You see the nature of the issue. This was a challenge to the convention compatibility of some of the consequential criminal offences that follow from a proscription. In that case, the proscription was Ammos. And you see the nature of the issue described in the certified question in paragraph 1. For the purpose of the point I want to make in relation to legislative context, the relevant paragraph is paragraph 18 on page 1793.
This case was after the decision of the Divisional Court.
Ten days after. Yeah, but after. So that's the general purpose, paragraph 18. That's all I want to make, BJ, for the purpose of this point. The second point is that Parliament has decided in that Terrorism Act, as the passage in paragraph 18 indicated, it's decided what...
Forgive me, what do we get from paragraph 18?
The general purpose
Right,
of the
I see.
Terrorism Act
Thank you.
is all
Yes.
I'm going to. I'm just setting legislative context.
Yes.
That's a short first point.
Yep.
Second point is that Parliament has decided what acts constitute terrorism for the purposes of the Act. And if you go back in the authorities bundle to tab 6, maybe a different volume from my labeling, sorry to jump around.
No problem.
Electronic page 26, the Terrorism Act. One of those that Parliament has decided is what acts constitute terrorism for the purposes of the Act. And you see from sub 1 on page 26, that terrorism means the use or threat of action where the action falls within sub 2. And then the cumulative conditions in 1B and 1C, but it's the action that's of some interest here, sub A of 1. And then sub 2, action falls within this subsection if it involves A, serious violence against a person, or B, serious damage to property. And you'll note from the or after subsection D within sub 2 that these are alternatives. So any one of those constitutes terrorism for the purpose of the Act. So it's defined terrorism in various alternative ways. And so Parliament has made the judgment that the definition both has alternatives and involves the actions that are there set out as the alternatives, including serious damage to property. And I should note at this stage that no challenge has been brought in this court to the primary legislation. It's not alleged that that's incompatible with convention rights. The legislation is assumed to be compatible for the purpose of the appeal. Just flicking forward now, you're in the Act to section 3 on page 28. Can I just invite you to cast an eye down the structure of section 3? You will see that an organisation is proscribed if it is listed in Schedule 2. And the section then sets out when it can be listed in Schedule 2. So you'll note, as I indicated earlier, just pausing on 3.1, that there is the legislative technique, as it were, is that although the prescription is made by the Secretary of State, and as we'll come to see, it can only be made if it's made under section 3 by affirmative resolution procedure. Section on that in a minute, I think it's 1, 2, 3. The way in which that is affected is by amendment to the primary legislation in Schedule 2.
James, could you just go back to section 1, subsection 2? You took us to A and B. Are they the only relevant alternative forms of action falling within the subsection for our purposes?
My lady, I think the focus has been particularly on 2B, because that is the one that chimes most directly with the JTAC assessment, which we'll come to in due course.
I understand.
But I don't think it was made on any of the other bases,
Right.
although some of the underlying action might be thought to drift quite close to some of them.
All right.
I can put it that way. There's also quite a fine line between the one thing and the other. So that's what we say about that. Sorry, back to 3, if I may. I know there's no further questions on 1. If you look at 3.3 then, please.
But before we leave 3.3, we've talked about the decision and the order. The legal instrument that brings about the proscription is the making of the order, though. So do we take account of things up to the date of the initial decision or up to the date of the making of the order?
I think you
Does it
take it
not
up to the
matter?
you would take it up to the making of the order in terms of time. The only reason I was flagging the Schedule 2 bit is because there was an issue which was, as it were, ducked, if I'm allowed to use the technical legal term, when we came to arguing about or having a discussion with the court about remedy below. And obviously, if the effect of the order is to lead to the amendment of primary legislation, there may at least be some questions arising, which I'm not going to trouble you with now, but I simply flag. There may be some questions arising about how that works under the scheme of the Human Rights Act. It was possible to duck it below because the bases on which the claim succeeded included the claim about the policy. And so there was an alternative basis, as it were, which didn't simply turn on the amendment of Schedule 2. So subsections 3, 4 and 5, can I just invite you to cast an eye down? In essence, what has to happen is that the Secretary of State has to believe that the organisation is concerned in terrorism, and we've seen the definition of terrorism, and whether or not they are concerned in terrorism is then the subject of its own definition in 3.5. As you see, there are various ways in which someone can be concerned in terrorism, and we'll see those reflected when we get to the judgment already. So it covers committing or participating in acts of terrorism, preparing for terrorism, promoting or encouraging terrorism, or being, catch-all, quote, otherwise concerned in terrorism. Just in case a catch-all is needed. And if those tests are satisfied by the actions or some of the actions of an organisation, if I can put it this way, the powers are available. There is, of course, a discretion. This is a may provision, not a must provision. You see that from section 3, sub 4. But Parliament did not choose to impose, if I can put it this way, any additional constraints on the availability of the otherwise untrammelled Secretary, expressly untrammelled Secretary of State's power to proscribe, and did not, for example, make any sort of precondition that the activities had to be at a certain level, scale, or persistence to fall within the scope of the power. So the may is a true may. I know we're not allowed to refer to untrammelled power, because no power is untrammelled, but it is trammelled by the principles of public law, not trammelled expressly by anything that Parliament chose to impose, despite the detailed definitions that it did provide. So my second point was, strayed rather off it, but my second point was that Parliament has decided what acts constitute terrorism for the purposes of the Act. Third point is that it is also a judgment for Parliament to decide, and they have exercised that judgment, what consequences should follow if an organisation is proscribed. And again, can I invite you, as the first sub-point under this third point, to go back to ABJ, if you would. tab 49, starting at page 1785, and the paragraph I want for this purpose is paragraph 29 at the bottom of page 1796. So 1796 in the electronic, at the bottom of the page if you would, and can I invite you to read paragraph 29?
Yes.
So as the Supreme Court there points out, prescription isn't an end in itself. It achieves its effect through the consequential provisions. And Parliament has decided that the appropriate course is for the range of prohibitions that the Terrorism Act then sets out, all of which are then backed by criminal sanction, which is why you end up in the sort of territory that ABJ sits in, with people challenging the nature of the criminal offences and whether or not they're disproportionate. It's decided that the appropriate course is for that range of prohibitions backed by criminal sanction to apply upon proscription. And if you want a pithy summary, I'm not going to invite you to turn it up, but if you want a pithy summary of the nature of the criminal offences that are potentially in play following proscription, you could do worse, if I'm allowed to put it that way with some understatement, than Mr. Justice Chamberlain's judgment on the interim relief application at paragraphs 33 to 39, summarising the criminal offences. That is in the authorities bundle. I don't invite you to turn it up now. Tab 45, those paragraphs you will find at 1639. So the structure of the legislation, as the Supreme Court has noted, is that those consequential provisions, i.e. consequential on proscription, take effect as a fixed suite of general measures which are positively designed by Parliament and evidently designed by Parliament to disrupt and stifle the proscribed organisation by precluding vocal and financial and following support for a terrorist organisation which Parliament has decided can be listed in Schedule 2 to the Terrorism Act. And the Secretary of State, you will note, has no power to tailor those measures. That's why I say they take effect as a fixed suite of consequential measures. The Secretary of State can't say, well, I'll have that one but not the other one. They all follow from proscription. The final sub-point in relation to the consequential provisions is that Parliament was alive to the fact that those powers conferred on the Secretary of State with those consequential effects were significant powers, and that those effects were significant effects, unsurprisingly, given the range of conduct that would then be prohibited, and given the backing of that prohibition through the criminal law. If it wasn't already self-evident, it is clear the fact that Parliament acknowledged that that was a serious business is clear from the fact that it mandated a procedure under which it was able, that is, Parliament was able to consider and put or not its democratic stamp on any decision by the Secretary of State to proscribe under Section 3. And if you go back to the Act, if you would, I said I would show you Section 123. If you go to tab 6, page 103 in the numbering, just located on the page before 102, which is the start of Section 123, and you'll see in the usual way this legislation makes various provision for subordinate legislation, and these are the rules that govern, the primary legislative rules that govern the way in which orders or regulations are to be made. And the one we're concerned with, which is why I gave you the reference to 103, is sub 4. And you will note that sub 4 deals with an order or regulations under any of the following provisions shall not be made subject to sub 5 unless a draft has been laid before and approved by resolution of each House of Parliament. That's what I refer to as the affirmative resolution procedure. And you will see that A refers back to section 3.3, which is our power. So you need affirmative resolution procedure subject to urgency, which is the stuff of sub 5, as you see on towards the top of page 104. So that's the way in which Parliament has set things up. But formally, and as a matter of law, and despite the affirmative resolution procedure, as we know, the decision is still the decision of the Secretary of State, for which the Secretary of State is answerable, even with the democratic stamp that Parliament has necessarily had to give it before an order can be made. And so it is subject to the Secretary of State's satisfaction. This is the fourth point on legislative context. The decision under challenge is a decision of the Secretary of State, as we acknowledge. I made a point already about the nature of that power. It's simply a may, with no further preconditions beyond those Parliament has seen fit to set out, but subject, of course, to public law. And what that means is that Parliament has afforded primacy in making the judgments that are inherent in a decision as to whether or not to prescribe. It has afforded primacy to the Secretary of State in terms of decision-making in this area. That is perhaps unsurprising, given that the context involves the pursuit and the protection of national security and the other public interest objectives that are sought to be achieved whenever an organisation is proscribed. Just one further reference back into ABJ, if I may. I'll come back to this because I'm almost incapable, I think, of doing a case in this court without mentioning the margin of appreciation. This will be no exception. So I'm going to come back to this a bit later when we're dealing with the substantive convention issues. But the paragraphs I want for this purpose in ABJ are 106, particularly 106 for this purpose at page 1821 behind tab 49. My ladies and my lords may recognise the tenor of that paragraph.
Yes.
But it's of some interest, perhaps, beyond the usual submission, which you'll be very familiar with, based on Raymond and recent authority in the Supreme Court, like U3, in the context of SIAC and deprivation of citizenship, which I'm going to come back to on margin anyway, but of some interest, perhaps, in this case, because they apply that principle and that approach by reference to that domestic authority, but also by reference in the context of political speech to the European authority that they mention in the second half of paragraph 106, the Schwebe and Germany and the International Humanitarian Health Organization case. That's all I wanted to say in relation to the legislative context. I wanted to make a few points, if I may, on the facts. And I'm going to split the points I want to make on the facts into two sections. The first section is going to deal with the nature of Palestine Action and its activities. That's going to be section A, in relation to points on the facts, and then section B is going to be 3 or 4 short points in relation to the decision-making process, if I may. So, first part of that, A, the nature of Palestine Action and its activities. 6 points on that. The first is that Palestine Action met the statutory definition of being concerned in terrorism. I don't invite you to turn it up now. You've probably got the judgment of the Divisional Court loose, but I'm going to give you references as I go into that judgment. I'm going to try and take most of these points from the judgment, which hopefully make a series of findings of fact, virtually none of which people quibble with on this appeal. That point I've just made, it met the definition of being concerned with terrorism, the Secretary of State's belief that they were. Judgment 134. As such, the legal questions in this appeal arise exclusively in respect of the exercise of the Secretary of State's discretion to proscribe Palestine Action upon the statutory test having been met.
Sorry, forgive me. The judgment below, paragraph...
134, my lady. It's really the second half of that in this case.
Yes, yes, I have it. Thank you.
Sorry, I should have given you
No,
the
no, no,
second half.
you were quite right. Thank you.
The second half. In this case, the Home Secretary is concluded.
It's correct that that assessment is not challenged in the divisional court and is not challenged before us.
Yes. So the legal question, the point I was making on the back of that, was that the legal questions in this appeal arise exclusively in respect of the exercise of the Secretary of State's discretion upon that statutory test having been met.
Does it say which bit of the subsection it is based on, whether it's property or anything else, or is it just...
My Lord, I think it was based on property.
It was based on property.
Yeah. I think they tracked the JTAC assessment, which based it exclusively on property.
Is that in the subsection?
Well, it referred to some of the other incidents that you'll have seen, which I'll come back to.
Yeah.
But perhaps important to note that there were three, and again, we're jumping forward a bit, but I'm sure in your reading you'll have spotted, not least from the JTAC assessment, that there were three particular incidents of concern, which I'll come back to in due course. But it's important for the purpose of this point to note that although three incidents were assessed contemporaneously to have met the definition of terrorism in section 1.1, as we've seen, prior to the decision being made. Of course, I put it that way because Bryce Norton happened in the run-up to that. Although there were three particular points, the divisional court were not prepared to infer that those three incidents, meeting the threshold of terrorism,
Were outliers. Yep.
were outliers.
Yep.
My lady has the point. Were outliers, as they put it in the judgment at paragraph 28, they were not prepared to infer that they were outliers as to scale and extent, and were not therefore indicative of Palestine Action's activities. They were not prepared to infer that. In terms of the characterisation of their actions, which met the definition of terrorism, we looked at 134. If you have the judgment to hand, can I invite you to look at 137? And I wanted to pick it up about 6 or 7 lines down. Do you see the line beginning 2000 Act within the United Kingdom? Mm-hmm. Can I invite you to read from there, any such action is the antithesis to the notion of a democratic society that is the foundation of the ECHR. And I invite you to read to the end of that paragraph. That's the first point. Met the statutory definition, not prepared to conclude that they were outliers, and that's how they characterised the actions that actually fell within. But secondly, second point on the facts of second of 6, Palestine Action has, as the Divisional Court concluded at paragraph 23, which I invite you to go back to, of the judgment, has, quote, a wide range of targets. just remind yourselves of paragraph 3, and when you do, you'll see that the wide range of targets happens about halfway through that paragraph. And again, just a couple of sub-points under that. The main target of Palestine Action's activities in the United Kingdom, the Divisional Court concluded, is Elbit Systems. See judgment paragraph 16(1)(6). However, as they concluded at paragraph 17, Palestine Action's activities are, quote, from paragraph 17 of the judgment, also directed at any other company or organisation considered by Palestine Action to enable Elbit's business in the United Kingdom. And the breadth of the term, other company or organisation, is illustrated by the contemporaneous records. So, if I may, give you some references. The ministerial statement of the 23rd of June 2025, just before the decision was made, is announcing the decision. That's at tab 18 of the core bundle, electronic 174, hard copy numbering 138. So, core bundle, electronic 174, is the statement to Parliament made by Yvette Cooper, who was then the Secretary. And you will see in the, if you go to page 174 or 138, which is the second page of the statement, and if you go about 4 paragraphs up from the bottom, what it will do is enable law enforcement. Does the court have that paragraph?
Yes.
The sentence I want really is after that. Only last month, Palestine Action claimed responsibility for an attack against a Jewish-owned business in North London, where the glass front of the building was smashed and the building and floor defaced with red paint, including the slogan, "Drop Elbit." The JTAC assessment is, I'm afraid, in a different bundle. This is the first agreed supplementary bundle.
Is this your third point?
No, this is still on the
not
second. I'm just giving you examples of what other company or organisation means, the breadth of their activity. I wanted the JTAC assessment, which was annexed as Annex B to the ministerial submission of the 26th of March 2025. And the page I want for present purposes is page 176 electronically, page 167 in the hard copy. So 176 of the supplemental bundle. And I hope you should have a photograph on the right-hand side of that page with bigger A's underneath it. Can I just invite you to read paragraph 50?
Forgive me. It's the first of the second agreed supplementary bundle, is it?
No, it's the first supplementary bundle.
Right. The agreed supplementary bundle.
Yeah, the agreed. I'm just going to call that agreed because I'm never going to go to the second.
No, all right. So
I want
176.
tab 10 of that,
Yes,
which starts at hard copy page 145.
I have it.
And then can you go to page 167?
Thank you.
This is an annex to the 26th of November Min Sub. This is the JTAC report. And I want paragraph 50 on hard copy 167 and electronic 177. A photograph top right hand corner.
Yes, I have it.
Could I invite you to read
I
paragraph
see. So that's the
50?
yes.
This is about the breadth of their activities. Then if you
Yes.
and then if you go forward, if you would, for this purpose, to the CTP Counter-Terrorism Policing Report on Palestine Action, which starts behind tab 19, electronic 263, hard copy 254. So this is the counter-terrorism police perspective on things. Again, this was appended to the men's sub of 26th of March. And what I want in there is page 268 electronic, 259 hard copy, under the heading Recent Incidents. And I invite you to read the first paragraph under Recent Incidents, which is the title about a third of the way down that page, 268 electronic, 259 hard copy. So this second point is effectively wide range of targets.
On the target here being the bank.
Yeah.
Yeah.
The third point I wanted to make on the facts is that although Palestine Action's activities have been repeatedly referred to by the respondent as direct action, in inverted commas, they've made that reference and used that characterisation both in evidence and in submissions. Our submission to this court is that that term needs to be approached with a little caution. Palestine Action was not engaged in what can properly be described as civil disobedience, mere civil disobedience. That was the divisional court's finding, paragraphs 21 to 23.
And this is the subject of challenge in the respondent's notice.
That was the finding of the division,
Yes.
21 to 23. Judgment paragraph 30, the divisional court held that, and I quote, the picture the claimant seeks to paint of an ordinary protest group engaged in activities that fall within the well-established tradition of peaceful protest is not an accurate picture. That's the conclusion of the divisional court at paragraph 30 of the judgment. Rather, their activities, as the divisional court found at paragraph 21, were, quote, for the most part, various types of criminality. And as they also concluded at paragraph 25, those activities were undertaken with, quote, from paragraph 25, no suggestion of restraint or proportionality, and with the encouragement of the absence of restraint being repeated at paragraph 26 of the judgment. And you can see why they concluded that. If you still have that agreed supplementary bundle to hand, if you go within that bundle, if you would, to page 178 in the electronic, page 169 in the hard copy. Sorry to jump around there again. 169 in the hard copy, 178 in the and you will see there's some very small print under step 4. This is from the Palestine Action, quote, underground manual, as you see at the top of page 168 in the hard copy, 177 in the electronic. This is Annex A to the men's sub, Palestine Action underground manual, and look at step 4, plan your action. And as the Palestine Action, plan your action, step 4 said, dream up crazy ideas in your cell. That was a reference to the organisational structure that they recommended to make detention and prevention difficult. Dream up crazy ideas in your cell. Remember that your action is to disrupt, damage and destroy your target. And further, under a subheading, think big, the underground manual stated the tactics mentioned are examples of previous actions, so by all means think big. Try not to limit your action based on what's been done before. Remind yourself when brainstorming different ideas, what could I do to be creative? And as the divisional court also found, a major part of Palestine Action's funds were directed to supporting those sorts of activities. See judgment, paragraph 20. And on that basis, this is the fourth point, the divisional court held, this time paragraph 29 of its judgment, that it was not sustainable, quote, to portray Palestine Action as a non-violent organisation. And we respectfully submit that that finding by the divisional court gives the lie to the respondent's attempt now, including in its skeleton argument of paragraph 51(4), to characterise the actions of the organisation and those who support it as being, quote, part of a long and honourable history of civil disobedience on conscientious grounds. That's completely at odds with that finding, we respectfully submit, and the wholesale rejection of that submission made by the respondent below at paragraph 30 of the court's judgment. As they put it at paragraph 25, the divisional court, Palestine Action, I quote, encourages the causing of more rather than less harm. And they express particular concern about the content of the underground manual which you saw with the little writing that we've just been to, which encouraged the use, as they found in paragraph 27 of the judgment, of, quote, an efficient sledgehammer in circumstances in which JTAC's expert assessment of one of Palestine Action's attacks, which had met the definition of terrorism, was that, and I quote from paragraph 34(1) of the judgment, those participating in the Bristol attack had entered the Elbit warehouse using weapons including sledgehammers, axes and whips, and during the attack, 2 responding police officers and a security guard were assaulted and suffered injuries. One police officer had been assaulted with a sledgehammer and sustained a serious back injury. The fifth point I wanted to make on the facts is about escalation. The Secretary of State's
So
expert
which was the
advice.
fourth? I'm still on 3. Where's the fourth one?
Fourth one was divisional court holding it wasn't sustainable to
Right.
portray
Yep.
Palestine Action as
Thank you.
non-violent. Sorry, Mary, that
No,
could,
no,
have,
that's
could have
fine.
emerged into 3.
No, escalation.
That's the fourth one. Fifth one is escalation. Secretary of State's expert advice was that Palestine Action's activities were on an escalating trajectory of seriousness. Can I just give you some references to this without necessarily inviting you to turn it all up? The 26th of March ministerial submission, quoted at paragraph 43 of the judgment, found that, firstly, Palestine Action is responsible for an escalatory campaign of direct action across the UK that has crossed the threshold into terrorism. That's paragraph 18 of the MinSub, agreed supplementary bundle 148 in the hard copy, 157 electronically. Secondly, from that MinSub, that evidence collected through police investigations indicates Palestine Action members have intended to further escalate the seriousness of activity. That's paragraph 23, same page, 148, electronic 157. A JTAC assessment at paragraph 1, which was annexed to that March ministerial submission, included, I quote, whilst Palestine Action has conducted direct action since its inception, grievances associated to long-standing Israel-Palestine hostilities, including escalations since the attack by Hamas on the 7th of October, highly likely contributed to an escalation of PAG's activities in 2024. References into the same bundle, hard copy page 159, electronic 168. Then the 2nd of April 2025 MinSub, paragraph 4, concluded the CTP, that's the Counter-Terrorism Police, agree with the assessment that Palestine Action is predominantly involved in direct action that consists of criminal damage to property, but that its activity has escalated in seriousness over the past 18 months. 2nd of April, Mensub, para 4, same bundle, page 216 in the hard, 225 electronically. And the escalatory nature of Palestine Action's campaign was, we submit, demonstrated clearly in the incident involving Bryce Norton, RAF Bryce Norton. And you have a description of the nature of what went on there in Jonathan Sinclair's second witness statement at paragraph 5, same bundle, this time tab 4, pages 36 to 37. That's both a hard copy reference and an electronic reference, 36 to 37. As the ministerial statement that we've already seen of the 23rd of June noted, I'll just remind you of the reference, that's in the core bundle, tab 18, page 137 to 138, electronic 173 to 174. As it noted in the Secretary of State Statement to Parliament, those activities of Palestine Action have increased in frequency and severity since 2024, and its methods have become more aggressive. And as the Home Secretary also pointed out, based on that counter-terrorism police report, the group has a footprint, as she put it, in all 45 policing regions in the United Kingdom and has pledged to escalate its campaign. The sixth point is that information about Palestine Action's membership, funding and structure was very limited, not least because of how Palestine Action had intentionally formed, we saw this in the Underground Manual, we've seen it in the men's subs, had intentionally formed into cells, and its members were encouraged to take precautions when communicating with each other. Those are the subject of findings in the Divisional Court's judgment, particularly at paragraphs 18 to 20 and 24. As they concluded at paragraph 19, quote, "It is entirely unlikely that an organisation committed to achieve an objective through direct action would do nothing to direct that action to its best effect and would have no structure to promote action." And describing the role of Miss Ammori herself, the Divisional Court found, this time at paragraph 65, how and to whom, they said on behalf of Palestine Action, prior notification could have been given, this in the context of prior arrests, is not clear. She provides no description of Palestine Action's organisation other than referring to the existence of different working groups for different things. No doubt, the Divisional Court concluded, this lack of information about the leadership or organisation of Palestine Action is intentional and is consistent with the image of a covert organisation that is cultivated in the Underground Manual. That's paragraph 65. That's the first part of the factual bit. The second part relates to the decision-making process. So this is B, and I wanted to make all the points together under 4 points. I think Mr. Hussain might have sent the court a letter requesting a comfort break. Could
Of course.
I, on his behalf, request that now?
Of course. Mr. Hussain, would you like us all to rise? We have been in communication. No. Please, take your leave. Thank you. And I think you're happy for us to continue in Mr. Hussain's absence? Yes. Yes.
A detailed account of the decision-making process is set out in Mr. Sinclair's first witness statement, if you want it, just by way of summary, paragraphs 3 to 20. That's in the supplementary bundle at pages 32 to 34, both hard and electronic, same. 32 to 34 of the supplementary. Mr. Sinclair's first witness statement. I was to make, as I said, 4 points under this. Firstly, the Secretary of State was advised throughout by an expert and experienced group on the security side, considering both the actions and threats of Palestine Action and the benefits of proscription. You had the benefit of advice from something called the Proscription Review Group, the PRG, that you'll see reference to, directly reporting to the Secretary of State on possible proscriptions and providing advice in relation to them. And they themselves, as we have already seen, were supported and advised by a range of experts, including JTAC, the CTP, the Counter-Terrorism Police, on the security side, and others in government. And the unanimous conclusion and recommendation of all of those groups, the PRG, JTAC, CTP and others, was to proscribe. Secondly, in relation to key conclusions, on the justification for proscription in terms of the statutory tests being met. Perhaps in terms of time, I won't go to all of these, but can I just give you some references if you need them? Firstly, this is the justification for proscription. 26th of March 2025, ministerial submission. The key paragraphs for this purpose are paragraphs 5 to 7, 13 to 16, and 21 to 26. And you find that ministerial submission in the supplementary bundle, 146 in the hard, 155 in the electronic. So I think at the start of the paragraph. So 5 to 7, 13 to 16, 21 to 26 of the 26th March MinSub. In the JTAC assessment, which is probably the key document for this purpose, which was annexed to that ministerial submission, that starts, I think, at page 159 in the hard, electronic 168. And the key paragraphs on this justification point are 2 to 4, 2 to 4, 7 to 8. Quite a long section, probably the key section, because it goes through the different species of terrorism that we saw defined in the Act. 20 to 37, and then 47. Then the CTP assessment, that's the Counter-Terrorism Police assessment on justification of the 2nd of April 2025, attached to that, paragraphs 4 to 5. Sorry, that's the CTP assessment recorded in the ministerial submission of the 2nd of April, just to be accurate. So 2nd of April ministerial submission recorded in the CTP assessment, paragraphs 4 to 5. That's same bundle. Page 216 in the hard copy, 225 in the electronic. And then finally, the 4th of June MinSub, paragraphs 9 and 11, same bundle, 223, page 223 in the hard, 232 in the electronic. And of
Sorry,
course,
hard, 2-3,
223 hard,
thank you.
232 electronic. And of course, all of those references and all of that consideration is all in advance of Rise Norton. And it was confirmed before the Divisional Court that the Home Secretary had been informed and briefed about the Rise Norton incident. And I gave you the reference into Mr. Sinclair's second statement describing that incident. So that's the justification for proscription in terms of the statutory test. And on the benefits of proscribing, I might take you to this document. There was a CTP analysis, a counter-terrorism police analysis, which particularly considered the utility and benefits flowing from proscription in terms, in effect, of the consequential powers and doors that will be opened up, the suite of measures I referred to earlier. And that is in, if you go to the supplementary bundle, and you go to page 177 in the hard, 186 in the electronic.
Yes.
Perhaps if you just go back a page, sorry, to 184 in the electronic, 175 in the hard. Again, just to show you what this is the CTP report that is appended to the March ministerial submission, as one sees, from 172 in the hard, 181 in the electronic. Gives you that document, the 5th of March. And then you see it has various headings. But if you go to 175 in the hard, 184 electronically, you should see a title at the beginning of the page on existing legislation. And in effect, what this report does at this stage, does my lady do that?
Yes.
Yeah. What effectively this report does is to compare and contrast what could be done applying the existing legislation, the existing effectively the criminal offences and other possibilities, and then it compares it and contrasts that position with the powers that would be available to degrade and attack the organisation, as it were, if it is proscribed. So the existing legislation bit you see analysed at 175 in the hard copy, 184 electronic. Just to cast an eye down that, you don't need to spend long with it. The various offences that might be committed and so on, including potentially some terrorism offences, you see in the 3rd paragraph under that heading. If you just note the final paragraph on that page, 175 hard, 184 electronic, concerning the limitations.
So what's the hard reference to?
175. On the paragraph.
So James, can you just help on that last paragraph, sorry? I twisted round because of my position here. Talks about operation of existing legislation is seen as insufficient to address high-level offences. What's it driving at there? The sort of organisational element of the terrorism.
Not sure. Can I think about that? If I get a good answer, I'll let you know. It's like it's some deficiency considered in the existing criminal law for that type of offence.
But this is important because this is the perceived gap that was being plugged by the description. So
Well, it's a part of the gap. This would be in relation to the prosecution of particular offences. There are other things which will open up the prescription. But I'll check and see if anyone knows the answer to that, my lady. And the point I've just made is perhaps emphasised in the final paragraph on the next page, 176 in the hard, 185 in the electronic.
Yes, that would suggest that the answer to my lady's question is yes. Was heading at the organisational capabilities.
Yeah. What they're really, and the point they're really driving, and you see at the top of the next page, as the paragraph goes through, it's the reference to holistically. It's going for the organisation rather
Yes.
than ex post criminal offences. And you see that carried on in the first full paragraph on page 177 in the hard, 186. The first full paragraph from the perspective of regional police forces. You see that paragraph? Doesn't take it much further, but you see similar point. And then that is then the subject of
Read the next paragraph.
my learned friend would like you to read the next paragraph, PAG support strategy. But I'd like you to read that. And then if you've done that, the benefits of prescription, you see the title halfway down page 186, electronic 177 hard copy. And then you see the various benefits considered by the counter-terrorism police. Note perhaps in particular, if I may, invite you to note them, the two paragraphs in the middle of the next page, 178 in the hard copy, 187 electronically, the paragraph beginning, "It is argued." Can you read those two paragraphs for me, please? And then pithily put, similar point, I suspect it was this report that led to the summary to Jonathan Sinclair in the letter of the 6th of March, i.e. the day after this report, from the Counter-Terrorism Policing Unit. Look at electronic 190, hard copy 181, for that letter of the 6th of March. And in particular, perhaps, the final paragraph on that page beginning "direct action." I can invite you to read that and over to the next page, to the end of the first full paragraph on the next page. That would do those two paragraphs. And then you see the update of the 2nd of, in the 2nd of April ministerial submission. If you go forward to page 226,
Then there's a meeting of the PRG on the 13th of March.
there's a meeting at the PRG on the 13th of March, got the ministerial submission, and they kept meeting through March and into June.
Yep.
But we're now into April, just for the update.
Yes, sorry, yes.
Paragraph 7, the ministerial submission starts at electronic 225, hard copy 216. You see the date, 2nd of April. I want paragraph 7 of that, under impact of prescription, over on page 226 electronically, 217 in the hard. And you see the underlined bit saying DSNC. That's a reference back to the letter I think you just looked at, which was signed off by... So we've done the justification. I've given you some references for that, for prescription in terms of the statutory text. Done on the benefits of prescription. I've given you some references for that. But it's important to bear in mind that the decision-making also considers a range of other factors and risks with some care. And the only reference I don't invite you to turn up, it's quite a long section, but just to give you the flavour of it, see the 26th of March ministerial submission, paragraphs 18 to 40, considering a range of matters under the heading discretionary factors detail. So,
What page is that?
my lord, I'm sorry, it's electronic 157, and it's hard copy 148 and following.
Did these factors consider the effect on what one might call peaceful supporters of the Palestine Action group? Is that a feature that is found in these documents?
My lord, no, I don't think that is specifically done.
Thank you.
sorry, my lord, I'm so sorry, I
If
gave
we
you a
looked
wrong,
at page
I gave you
226,
a wrong answer.
there may be a partial answer to my lord's question on page 226.
Well, just before we get there, can I store that reference, as it were?
Yes.
And give you an earlier reference, which is on page 150 in the hard, 159 in the electronic. And just start at the bottom, sorry, just go back a page. 158 electronic, 149 hard. Right at the bottom of the page, you see a title, legitimate activity.
Yes.
And you see the paragraphs that then follow, so I'm sorry, I didn't.
So it did consider it.
Yeah. I should have drawn, going a bit quickly, I should have drawn attention to that. Can I invite you to read 32? In particular, the second half of 32. And 34, if you would.
Could we then pick up my Lord's point, Sir James? Which is, I think, a point on hard copy 217.
Yeah, it's electronic 226, where among the benefits of prescription, after the underlined passage, they talk about it will deny the organisation the opportunity to operate overtly, which will impact its campaign of direct action and significant resourcing cost this has on policing in the round, which appears to be an inhibition of its non-terrorist activity as a benefit of prescription.
My lord, in part, I think that's right.
Yeah.
I mean, there's going to be a debate about that when we come to one of the grounds of appeal, as you know,
Indeed so.
whether that's relevant or not. But the direct consideration of it, you saw in the minutes.
This page 27 seems to say it's a benefit that you're stopping lawful or overt action, isn't it?
Are you at 207 in the electronic?
No, I think it was 226, wasn't it?
226.
I was just looking at 226.
217 and a half,
Certainly.
226 electronic.
Electronic page.
I suppose it depends what you mean by operate overtly.
It does.
Well, I'm so sorry to interrupt. Could I just please ask you to speak up?
Oh,
We're
I'm
having
so sorry.
difficulty hearing you.
I thought, first of all, that paragraph 7 was against Sir James and in your favour, and I'm reading it again. I'm just trying to work out what it means at the moment. And I said it all depends on what the words, or might depend on what the words operate overtly means, whether they're saying it's a benefit to stop lawful protest, or whether the words overt action refers to people being able to support it.
Thank you very much.
But against all of that, I agree it's not entirely clear what that means, but go back to 32 to 34. It is that there's nothing that will prevent those who want to express support for Palestine Action for the Palestinian cause from doing so. I've given you the key conclusions on the decision-making process. The third sub-point I wanted to make was in the decision to proscribe Palestine Action, we'll come to this more directly when we come to the ground of appeal that relates to it, was informed and guided by the policy and issue under Appeal Ground 1, with careful consideration being given to broader issues bearing on the exercise of the Secretary of State's discretion to proscribe. And that document, just to show you it at this stage, and do no more, is in the same bundle we were already in, page 306 in the hard, 315 electronically.
And this is a public information document on government.uk website.
It is.
Yep.
And you'll see that the key passage for present purposes, which we'll never come back to, but the key passage is at the bottom of page 308 in the hard, 317 electronically. So 317 electronically, there's a title at the bottom of the page, what determines whether proscription is proportionate.
With the exception of this passage, is there anything else in this document that is a policy?
My lady, I'm not sure. I think the rest of it is just information and or description.
Talking about
Yeah,
the procedural and evidential requirements,
yeah.
list of prescribed and deprescribed organisations.
Exactly. I'm being whispered at. What
No,
is a
the
prescribed
first paragraph.
organisation? First paragraph. Mm-hmm. What is a prescribed? Yeah, I'm very happy to do that.
Well, that's
It's a weird document, isn't it, actually? And it has all sorts of things in it, including the paragraph everybody seems to love to quote. But having told you what stuff about aliases, prescription offences, penalties, whether the offences apply to all organisations. It says, how does prescription help disrupt terrorism? So that seems to be thought to be relevant. Do the offences apply overseas? That may be relevant too. I mean, it's not right, is it, Sir James, to say that you can just look at one thing in this document and get a complete and proper view of it? Or am I wrong about that?
No, you're not, my lord. I mean, you can look at a range of things. I think the debate was really directed as to whether or not this was properly to be called policy, or whether it was in nature more of an information document. And it's, as you rightly point out, it's a bit of a mishmash and a bit of a hybrid. It's called policy paper. I note against myself on page 306, hard 315, electronically on the first page. And a very large part of it is informational in nature.
Well, it's actually headed prescription criteria.
well, this section is,
This
and then
section.
and then
Yeah, well, then there's another one headed proscription
Another section.
offences.
list of prescribed organisations. Anyway,
Well,
I think
no, I think the problem is prescription criteria appears to be a more broad heading because it's
It's in
immediately
higher font.
followed by another heading.
It is, which is aliases, the next one. But
Yes, it's the next big heading.
my lord, you'll note, can I just invite you to note, so we don't spend too much time worrying about this necessarily, but can I just invite you to note that the policy was effectively adopted in a, if a policy it is, in slightly modified form in Annex A to the 26th of March ministerial submission that we've already looked at. And that is at page 165 electronic, 156 hard copy.
what was the modification?
Well, you'll see when you get there, it's this same bit.
Right.
So this is Annex A to the 26th of March min sub that starts at page 145 hard. And if you look at 156 hard copy, 165 electronic. Look at point 3.
It's faithful to the it's faithful to the policy
Yeah.
document
But it has the addition.
of Article 1011.
Exactly.
Yeah.
This is dragging in the ECHR. These are just factors.
But then it does matter because the real question is not what we call it, but what is its legal significance? And in particular, if you fail to have regard to one of the 5 factors listed, which was relevant, would you then have acted unlawfully? But if there are different factors, one expressly calling attention to the convention and the other not, might become more interesting as to know which is the one that you've got to take into account.
Well, my Lord, for that purpose, you'd have to assume that the policy document, which is descriptive, that we've just looked at 317 in the electronic 308 in the half, I don't want to get into this debate too early because I'm going to come to it directly, but you'd have to assume that that was intended, as it were, to operate freestanding and not as a range of factors that might bear on the proportionality of any interference when exercising the discretion, and that is plainly a duty to which the Secretary of State is subject under Section 6 of the Human Rights Act. And if you look at it through that lens, as it were, that this is very descriptive of the sorts of things that will be taken into account as part of the ECHR analysis, it all makes sense as a coherent whole, unless you're prepared to conclude that the document we looked at before is intended to be some freestanding straitjacket that is taken out of the context of the ECHR, which its title would rather belie, given the reference to proportionality, which is not a principle of public law, but a principle of ECHR jurisprudence. Well, I'll come back to that if I may, but I thought you ought to see both. The bullet point references to the factors are, as my lady, the Lady Chief pointed out, where that analysis leads, we saw from the ministerial submission itself, which went through, as the PRG had done, the variety of factors that we see there listed, as it were, and reached the conclusion that the thing would be proportionate. The fourth bit on the facts I wanted, and the final bit on the facts I wanted to clarify, to make submission about very briefly, was matters that happened following the decision. You've seen the process of decision-making leading up to the ministerial statement. The ministerial statement was then made on the 23rd of June 2025, and really the missing piece that's gone in by that point is Bride's Norton. A draft order was then laid before Parliament on the 30th of June 2025. It was approved by the House of Commons following debate on the 2nd of July 2025. Bear in mind we're doing affirmative resolution at this point. 2nd of July, House of Commons. 3rd of July, House of Lords. Approved. 4th of July, flurry of activity, including before 3 members of this court late in the evening. And order comes into force following the refusal of interim relief on the 5th of July.
And now the policy ground.
Now the policy ground. Exactly. Just at the limit of my lady's patience.
No, I haven't tested it at all.
Well, I hope that's at least helpful to frame some of it anyway. But appeal ground 1. And the core and overarching submission is that in determining what used to be ground 6, the divisional court erred in its interpretation and application of the Secretary of State's policy. We deal with it, as I said at the outset, in our skeleton 32 to 57. You want references back into the skeleton. And in relation to the proper approach to the interpretation of policies, again, none of this, I suspect, is going to be controversial, so I'll give you the references. If it turns out to be, always come back and reply and pick up any points of controversy, but I suspect this will be both uncontroversial and well known to the court. So can I just give you some references? 3 short points. 1, a policy is not a rule but a guide. That's the language of Lord Justice Sedley, giving the judgment of the Court of Appeal in a case called First Secretary of State and Sainsbury's Supermarkets. Paragraph 16, authorities, tab 15, electronic 368. Second, an overly strict or legalistic approach to the interpretation of policies should be avoided. The well-known principle that policies are not to be interpreted as if they were statutes or contracts. And if you want some Supreme Court authority for that proposition, Lord Reed in Tesco Stores at paragraphs 18 to 19, authorities, tab 20, page 578. Like me to
So
go
I'm just
there?
looking at the Sainsbury's case. Did you say what paragraph?
My lady, I did 16,
16.
1-6, I hope. I got that wrong.
I haven't got that. That's not the right reference, I think.
Let me go on to my machine. Well, I'm so sorry. Yes, this is a strange paragraph numbering.
Yes.
Yes, I'm sorry. I should. Go to the top of page 368.
Yes.
You'll see you've got a paragraph 1.
Yes.
That is in fact paragraph 16, but
Right.
then it goes even more haywire afterwards.
You?
Policy is not a rule but a guide. It's that final line. I'm so sorry.
No, that's fine. Thank you.
At least I have the page number right. Anyway.
You did.
That's 16. I did clock that. I should have mentioned it. The next point I gave you whilst you were searching for that was that an overly strict or legalistic approach should be avoided. Policies are not to be interpreted like statutes or contracts. I was giving a reference to Lord Reed in Tesco Stores, paragraphs 18 to 19, authorities, tab 20, page 578. And as Mr. Justice Dyson, as he then was, put it in Criminal Injuries Compensation Board ex parte K, not to be read, quote, in a complicated or excessively analytical way. That authority is tab 9, page 261, at the bottom. I don't think it had paragraph numbers. It's old enough not to have had paragraph numbers. 261 at the bottom is not to be read in a complicated or excessively analytical way. That's the second point. And thirdly, the reason for those first 2 rules or principles is that if the court were to adopt that sort of approach to the interpretation of policies, it risks assuming or drifting into the role of policymaker. And as Sir Keith Lindblom put it in Tesco Stores and Stockport, at paragraphs 36 to 38, that's quite a helpful summary of this approach, that is not a job for the judges. That authority is tab 42, page 1515. So that's the approach in principle. So far as the policy at issue is concerned, and I'm going to deal with that in a short section. I'm going to make some 5 or 6 points in relation to that, and then I'm going to turn to the divisional court's approach. Just on the policy itself is the next heading. We've seen the policy paper. It's a 41-page document written to assist the general public's understanding of proscription and de-proscription. The vast bulk of the document comprises information listing and describing proscribed terrorist organisations and explaining the process, as you've seen. The key passage you've also seen, that bit that straddles the pages. The policy recognises that not all organisations which meet the concerned in terrorism requirement would necessarily be proscribed, but instead that discretionary considerations of the kind non-exhaustively defined or identified might have that consequence. And that bit of the policy is, we submit, brief and formulated in pretty open textured language in terms of its non-exhaustive factors. And so both by reason of the nature of the document in which it was set out and by its own terms, it simply doesn't admit of sophisticated or legalistic interpretive analysis, or we didn't think it did. And there's a particular risk if the consequence of the court doing that is that it alters what appears to be the very nature or content of the policy and turns it into something which any natural person or any person given to this natural being would think it had. There was then, as we've seen, the modification, if that's the right way of putting it, of the policy in the ministerial submission. The policy, as you saw, was reflected in Annex A to that 26th of March MinSub. I should add, just for your note, that the modified policy in that way, same form, was then repeated in the June MinSub when they got there. So it was annexed as Annex B to the 4th of June MinSub, reference same bundle, supplementary bundle, page 236. Just check whether that's electronic. Yeah, that's 236 electronic, 227 hard copy. Same thing. Same reference.
The two odd things are, firstly, the policy that the public knows about is the one that's put on the website. They wouldn't see the ministerial submission. So it's understandable to look at the policy that's on the website. But the policy on the website doesn't actually say it must be proportionate. It says what determines whether it is proportionate. And then it lists 5 factors which are one analysis and non-exhaustive on another, which is said to be exhaustive.
Yeah.
But it's a very odd animal, page 308, isn't it?
But if it's odd in the sense that my Lord is suggesting that a member of the public would read that and think they don't have to comply with proportionality, I'm not sure I'd necessarily agree
But
with
they
that.
have
that
to
must
be
be wrong.
proportionate,
It's
but
clearly-
the definition of proportionate is not set out.
No.
And doesn't refer to Article 12 or Article 10 or Article 11, and just refers to 5 things, although it says there may be others. You
That's
think
true.
that-
Maybe it's trying to just
think
give...
you must take those into account in deciding whether it's proportionate.
But it's just giving practical illustration of how the discretion might be exercised and informative in identifying those rather than trying to summarise the relevant law. And an educated member of the public would know that the government is subject to Human Rights Act obligations under primary legislation anyway, Section 6 of the Human Rights Act.
But it says from your point of view, it wouldn't matter so long as they've considered those 5 things, if they're relevant. If you're right on your interpretation about other factors, you can include the other factors that are relevant to proportionality, and you say that's what the ministerial submission did. That's
Yes,
your-
I do say that, but I also say it would be an error to read this as though it imposed some form of straitjacket. It's meant to be descriptive, the factors are meant to be non-exhaustive. But in any event, if the concern is that ECHR didn't apply by the time that got to the minister, ECHR definitely had been introduced, unsurprisingly, because it was an obligation to which they were subject under primary legislation in any event. And the limbs of the proportionality test are in effect consistent with that proportionality test that we all know and love from Bank-Mellat and Schwedler and all those Supreme Court cases. And that was the version of the policy that was actually applied. This isn't a claim based on misleading the public, as it were, nor could it be. But so the question is, what did the minister do? And the minister applied the guidance that was provided to her in Annex B to the June 1 and Annex A to the March 1. You'll note that from the wording of the policy, however formulated, that at no point was it said in either the public-facing document or in the annex to the min subs, well, the purpose of this policy is to limit the use of the discretionary power to prescribe in some way. Just simply giving a list of non-exhaustive factors that will or should guide the Secretary of State's thinking to the extent that they're applicable and or relevant and or interesting. Ultimately, the obligation through the primary legislation of the Human Rights Act is on the Secretary of State to reach a decision which passes muster substantively under the ECHR, and therefore that must be proportionate. You know, that's an obligation of result of the process, misbehaving and all that line of cases, but it doesn't matter for this purpose. But the correct starting point here should have been that there was a broad discretion conferred on the Secretary of State by Parliament as the primary decision maker, back to the may and no further constraints as long as it was pre-provisioned in the legislation. The policy's evident purpose is to guide the exercise of that discretion to render transparent some expressly non-exhaustive factors, and they are expressly non-exhaustive, that will or might be considered in that context. That's what the policy is doing, to the extent that it's public-facing, and then when the Minister gets to apply it, the obligation under the Human Rights Act is, as it were, introduced through the reference to the ECHR articles. And I should add that the policy, as we've seen it in that nature, has been adopted and applied in every proscription decision without criticism or debate until these proceedings. And it's been applied in relation to a very wide range of organisations. But it obviously doesn't fall to be applied uniformly. It falls to be applied by taking into account those facts that are relevant to the exercise of the discretion, brackets, and or proportionality, because the ECHR constraint is ever present, is one of the restraining features of public law, if one wants to analyse it in that way. The matter was perhaps relatively accurately summarised, and I have to say that with respect to Lady Justice Lang, or Mrs. Justice Lang, she then was, in one of the POAC cases, called Arumugam. I just invite you to go to tab 28 of the authorities. Electronic 940, or Ampere 940. I'll give you a reference to 940 because I want paragraph 5. This is an open judgment in a case about the Tamil Tigers, I think. Yeah. That's these from paragraph 1 on page 939. If you look at paragraph 5, you see how she describes it. Appears that as a matter of policy, those will usually include, and then she sets out.
Well, I'm not sure usually, with respect, is right, is it? If you look at the policy, it depends how you read it. Doesn't the policy say you must, or she will, consider? Will take into account other factors
Take into
including.
account
So I'm not sure that the
other
usually...
other factors including.
Yes, absolutely.
May not matter to
I'm
me.
not sure that usually is.
I think in
spot
fairness
on.
to Lady Justice Lang, she was doing it by reference to a witness statement.
Right.
I can't remember for the life of me whether the policy itself was actually appended to that witness statement.
Well, there we go. Right.
There we are. You'll see I was on the point that the 5 factors identified in the policy may well apply very differently in each set of circumstances that arises.
Of course.
And one can take that, I don't need to label it, but one can take that from the paper itself in the supplemental bundle. see that the various different groups are then, that have been proscribed, are then identified and described, a whole range of them. Including Hamas at page 335, electronic 326, hard copy. That's Hamas.
What do we get from that? The fact that it
Simply-
was dealt with in
simply
different...
they get applied in a whole variety of different factual contexts.
Yes.
There will be some cases where not all 5 factors will apply, but insofar as all 5 factors apply, as I understand your case, you must take those into account, but you may also take account of other factors. And you shouldn't approach those other factors on the assumption that the policy means something particular.
Oh, yes, at its height against me, even though it's a caution in relation to that, because I mean the public-facing document is not necessarily, I submit, a mandatory will take them into account in all circumstances. The range of circumstances then may vary hugely. It's just giving a non-exhaustive list of things that may be relevant to a particular case. It's designed to help identify with the sort of things that might be considered.
Right, I think that's what my lord was saying. If it's relevant, then it must be considered. If on the
it's relevant,
fact,
you
if on the
take
fact it's a relevant consideration, as identified in that paper.
If it's a relevant consideration anyway, it would have
Yep.
to be taken.
You couldn't say one of these factors applies, but I don't care, I'm not going to take it into account. That would be a breach of the policy. If you said, I see that this applies, others apply, they point in different directions, or there are other factors still, and overall, the conclusion I reach is this. But if a policy says, you must take these factors into account, if there exists, they are things to be factored in. The way to give them, how they fit with others,
As a
will
matter of law.
depend.
My lord, that's a reading of it, and I accept that follows from the natural meaning of the word will,
Yes.
when coupled with relevance. But the only note of caution I was urging was that I'm not sure that the drafters of it were intending to impose that sort of obligation, rather than simply describing the sort of things that would be taken into account, or will be taken into account, as opposed to committing to do so in each case. I mean, I'm dancing a bit on the head of a pin, because if a factor that is listed is relevant to the decision anyway, it probably ought to be considered as part of the proportionality analysis anyway, which is
And
what
it's not
this
the
is really
issue for us,
directed
is it? It's all, this is all about other factors for us.
Yes.
That's the issue. So that's the sole issue on the policy ground, isn't it?
And of course, there is a broader point there, which is that it might be thought the policy's purpose is never designed to preclude, nor did it preclude, the Secretary of State from taking into account whatever factors she considered appropriate, subject only to rationality, including the 5 expressly illustrative ones identified in the policy. It merely shaped and guided that discretion. And ordinarily, as you know, the factors that are to be taken into account by the Secretary of State in exercising public law decision are matters for the rational judgment of the Secretary of State. Creed NZ, Lord Justice Laws in cartoon and all that line. We do not accept that the purpose of the policy is, as the respondent puts it, to direct the Secretary of State's assessment of whether there is, quote, a particular need to prescribe an organisation, that she falls within the Section 1 definition. The language of particular need appears to be taken from the Divisional Court's judgment at paragraph 91, but at no point does the policy ever use that language of necessity or particular need. The test is only ever described as one of proportionality. I turn then to the Divisional Court's approach to this, and our first submission, push on a bit I think, the first submission is that the Bank-Mellat style test was wrongly rejected, we submit. Skeleton powers 41 and 43.
Nothing turns on this, in fact, does it?
Well,
I'm not saying we don't need to address it, but
no,
nothing turns
I
on it.
think
It was,
I think they acknowledge that.
they
in the
acknowledged
judgment.
it would made no difference to the outcome.
Yeah.
Yep.
That's true, but it was a freestanding ground of unlawfulness. And I think what they meant by that passage that my lady has in mind is nothing turns on it because we found you're in breach of Article 10 and Article 11.
No, I'm not sure that's right.
Well,
but
anyway,
yes.
may I address it briefly anyway?
Yes, of course.
There was a common position below that proportionality in the context of the policy was indeed a reference to Bank Mellat style proportionality. And both parties had submitted that the policy imposed a Bank Mellat style test. See, for example, the claimant skeleton argument for that hearing at 118 to 119, full bundle page 206. The worry with that rejection is that it pays no attention to the policy and the form in which it was applied in the min subs. We've seen from that there was an express reference to the ECHR and the limbs of the Bank Mellat test of proportionality, with references to that. And by a Bank Mellat style test, the Secretary of State referred to there being a focus on the legitimacy and importance of the objective of the decision, its rational connection to that objective, whether a less intrusive means could have been used, and fair balance. In other words, Bank Mellat, Para 74, Lord Reed. And by treating the reference to proportionality in the policy, which was expressed with reference to the ECHR and the min subs, as a staged decision-making process, with which the Secretary of State was familiar and was bound to comply with any event under Section 6 of the Human Rights Act. You don't, if that's the position, end up with any legal absurdity of the nature that the Divisional Court identified at paragraph 79. You just apply the ordinary law. The first point is they didn't have regard to the way in which the policy actually operated with the Secretary of State, as we've seen. Second point is there was no and could be no principled objection or concern to treating the policy in that way. The approach didn't, as the Divisional Court put it at paragraph 79, contract out the decision-maker's decision to the court or require her to afford herself, quote, the latitude a court would ordinarily afford the decision-maker when applying steps 2 to 4 of the Bank Mellat test. It just simply didn't do that. The Secretary of State's got to apply the Human Rights Act anyway. And in doing so, the Secretary of State, as far as I'm aware, has never said, well, I'm a Secretary of State, so I'm going to afford myself a latitude or a margin. That is that would be an obvious error of law. That is a construct that the court uses in recognition of the factors that we saw identified in ABJ and a whole range of other cases to do with institutional competence and expertise. So it simply is wrong to say, well, that's the problem if you don't treat it in the way the Divisional Court treated it. I say the Secretary of State and her advisers were simply recognising that she was subject to the ECHR, so the decision needed to conform to that test. And the 5 non-exhaustive factors specified served to shape and guide what was in any event the Secretary of State's careful and multi-factor assessment of the exercise of her power to prescribe. She took into account expert advice, including on matters of national security. She took into account the public interest. She took into account foreign relations, all entirely normal and orthodox. No contracting out of the decision to the court is involved. As I say, she wasn't required to undertake some form of self-reflective inquiry and then accord herself a margin. That's not the way that ECHR works at all. The Divisional Court then seemed to have treated the substantial overlap of what was ground 6 with ground 2, that's the policy with the ECHR challenge, as a reason for rejecting the Bank Mellat style interpretation of the policy at 79 of their judgment, see penultimate sentence of 79. But the overlap is evident, of course, but it doesn't indicate that that's problematic. It was problematic to reject the Bank Mellat test for that reason, or approach for that reason. Indeed, to the contrary, as Mr. Justice Chamberlain recognised when he was dealing with the substantial overlap between grounds 2 and ground 6 at the permission stage, he initially refused permission precisely because of that overlap. But the point is that the fact that there is an overlap is self-evident because the factors bear on the discretion and they bear on the ECHR analysis. So the first submission is that the Bank Mellat style test was wrongly rejected. The second point is
I see what you mean about paragraph 81, where there's a reference to this would make no difference to the outcome of this case. But if one is posing the counterfactual, or even if we're wrong, and the policy required the Home Secretary to apply the Bank Mellat style approach, would you not expect the Divisional Court to have gone on to say, and if we're wrong about this and you apply a Bank Mellat style approach at the policy stage, she would also have fallen foul of her policy in those circumstances?
well, I think that's problematic. Yeah, I agree with that, but it's problematic because this policy was treated as a freestanding ground.
Well, I understand.
Yeah. And it is not entirely clear, but it doesn't matter. I've made my submissions on
All right, okay, thank you.
Second submission related to the nature of the interpretation of the policy. We submit it's a strict and legalistic interpretation of the policy that has been adopted. They define proportionality as used in the policy for themselves. And they do that in paragraph 80 of the judgment. They don't just treat that, as it were, as a proportionality under the ECHR. They can define it for themselves. Now, how much difference it ultimately makes, because it looks remarkably like an ECHR description of proportionality anyway, but they're certainly treating it as something rather different. But then the Divisional Court's interpretation of the policy then comprises, and this gets to the heart of it, then comprises 3 steps. If I can identify those. They held that the purpose of the policy was, quote, from paragraph 83, clearly to constrain use of the discretion so that not all organisations that meet the concern in terrorism requirement will be prescribed. See also to limit the use of the discretionary power to prescribe. Judgment, paragraph 91 for that latter reference. That's the first stage. Second stage, they reinforce that conclusion by then engaging in they submit as a pretty intricate and legalistic analysis of the policy, the substance of which was, in essence, to apply the justem generis principle of statutory interpretation to the policy.
Were they taken,
from
forgive me
paragraph...
for interrupting, were they taken to the authorities, the Tesco stores, Sainsbury's authorities?
yes, I'm sure there were references
all right.
to that.
Okay.
Fine, I'm sure.
There's no
citation.
There's no citation of those
No,
cases.
but I don't think that was controversial.
Sorry, I interrupted you.
I was doing a justem generis, if I was allowed to use Latin. Of the substance of that you see in paragraph 91 of the judgment. Particular sentence, but whether generic or specific to the organisation under consideration, the factor must contribute to explain the particular need to prescribe that organisation above and beyond the necessary belief that the organisation is one that is concerned in terrorism. So you've got to justify it on that basis, according to the policy. 91. Thirdly, having determined that all of the factors must be construed as restricting the Secretary of State's power to proscribe, the Divisional Court then held that the policy ordinarily precluded the Secretary of State from considering, 94, the operational consequences and advantages of prescription arising under the general law, including the disruption of the organisation in question.
Well, this is the key paragraph.
Yeah. So operational consequences and advantages of prescription is a necessarily irrelevant factor. However, they then held that in principle that was subject, there was an exception to that ordinary position if, in a particular case, by reason of the organisation structure, membership activities, or otherwise the measures in the 2000 Act that are the consequences of prescription would be unusually effective. So they've introduced, as you will see, a positive bar on taking into account under the policy, a positive bar on taking into account operational consequences and advantages of prescription. And then they thought, oh, hey ho, that might not work terribly well. Let's introduce an exception as well. So that's what they do in 94, and as my lady says, that's probably the guts of it, but that's the third step. As to the first step, that's the policy operating as exclusively and in its entirety a constraint on the Secretary of State's discretion. My submissions are these. Properly interpreted, the policy does not operate to limit the Secretary of State's discretion in all of its provisions. It makes no provision to that effect. And on its natural and proper interpretation, the short and open-textured policy was drafted so as to guide, not to straitjacket, the exercise of the Secretary of State's discretion to prescribe an organisation that is concerned in terrorism. The fifth factor, it might be thought, the need to support other members of the international community in the global fight against terrorism, might be difficult to reconcile with the Divisional Court's approach that every provision of the policy constrains the Secretary of State's discretion. Because such a requirement in relation to that fifth factor would fundamentally impede the Secretary of State's ability to do precisely what it says, namely to take steps in support of international partners and allies. And the position of Hezbollah that we saw, that you can see in the description in the policy document itself, demonstrates that the Secretary of State's consideration of, quote, the need to support other members of the international community in the global fight against terrorism, operated in that case to support Hezbollah's proscription and not count against it.
Sorry, it's my fault. I just don't follow this point. You say, obviously, the fifth factor is the need to support other members of the international community in the global fight against terrorism. What do you say is offensive about the Divisional Court's analysis by reference to that factor?
They treat all of the factors as being, in effect, a constraint on the Secretary of State's power and on the Secretary of State's discretion. But this fifth factor is, as it were, a positive feature that could be relied upon to support it. And so it doesn't sit terribly well with that overarching analysis. That's the nature of what the policy is doing. That's the only short point I wanted to make.
I see, thank you.
The correct approach we submit is not to treat it all as a straitjacket which, with all the factors operating to constrain and so on. The correct approach is to recognise that by the time you get to discretion, you've got an unchallenged, as here, finding that the statutory threshold concerned in terrorism is met, and in our case was met by Palestine Action's actions. That a broad discretion has been conferred on the Secretary of State by Parliament, that discretion is to be exercised just as a matter of public law, consistently with the protective purposes underpinning the legislation, that is protective of the public. But that the Secretary of State, like any other authority, and whenever she exercises powers of this kind, is obliged by Section 6 of the Human Rights Act to act compatibly, and so she must act proportionately. And the policy's purpose against the background of those principles, those base principles, is to guide and not to straitjacket the exercise of that discretion and or her consideration of proportionality. Bearing in mind that from proportionality perspective, what matters is not the process, misbehaving and so on, but the outcome. So its purpose ultimately was not to preclude the Secretary of State, as a matter of public law even, from taking into account whatever other factors seemed rationally appropriate to her, including the 5 expressly illustrative ones identified in the policy. policy, I should say, expressly and clearly recognised, as did the men's sub, or the men's subs, that not all organisations that meet the concerned in terrorism requirement would necessarily be proscribed. That follows from the structure of the legislation. It's a precondition, as then a may. And then the consideration has to be, what about the discretionary considerations of the kind non-exhaustively defined in the policy, which might have that consequence for or against? However, the recognition of that fact, in other words, that there is a discretion, does not limit or preclude the matters the Secretary of State is entitled to take into account. As to the second step, that's the justem generis principle, our submission is that this was neither an appropriate, this was not an appropriate way to interpret the brief, open textured statements that we've seen in the policy and in the annexes to the website. Nor was it supported by the terms of the policy. The effect, in a nutshell, and we bear in mind at this point Sir Keith Lindblom's adjuration against the court's entering policy and redrafting policy, the effect of applying that principle was that the divisional court introduced restrictions, in effect, that the Secretary of State had elected not to include. And that's because when it got to it, it used that approach to limit the nature and scale of the organisation's activities, that point, to only such activities as amounted to terrorism within the definition of Section 1. That's what they were using this for. That was the punchline of that point. As I say, there's no proper basis in the text, we submit, to conclude that the policy was designed to or did preclude the Secretary of State from taking into account whatever factors seemed rationally appropriate to her. Indeed, the list of expressly non-exhaustive considerations points the other way. And there's no good reason in principle, we submit, why the activities of an organisation which are not themselves terrorist in nature, but are, for example, only, if that's the right way of describing it, only criminal, should be treated, or indeed should have been intended by Parliament to be treated, as irrelevant to the exercise of the discretion to prescribe. And that's the punchline. That's what they use this for, the division. You can't take into account activities that don't amount to terrorism. And that conclusion would also have perverse consequences, including that an organisation's activities cannot be considered by the Secretary of State. That activities cannot be considered by the Secretary of State at all if the statutory threshold is not satisfied. In other words, they don't meet concerned in terrorism, those activities, regardless of their escalation in frequency and seriousness, and regardless of what may be prospective assessments of the organisation's future activities and thus present risk. And that would undermine, we submit, the precautionary approach that Parliament plainly intended to permit the Secretary of State to take. My submission is that the Secretary of State ought properly, and Parliament must have intended, to be able to turn her mind to those activities of an organisation that is in fact concerned in terrorism, some of its actions, but then to consider other activities of the organisation that may currently fall below the terrorism definition in the context of escalation, and which expert advisors assess might come to meet that definition.
You say that this approach to terrorism, to what is the meaning, you say a limiting factor, that it has to be only terrorist activities. But in fact, the apparent basis for the divisional court rejecting the legitimacy of looking at operational consequences was not linked to the fact that those were not terrorist activities. It was linked, appears to have been linked to the fact that the divisional court stated in its view that such consequences and advantages would apply equally to any organisation that could be prescribed. So the finding of unlawfulness wasn't based, as I see it, or connected with the divisional court's approach to the narrowing by reference to terrorist activities only. It was a separate point altogether.
Well, my lady, I think that with respect, I've read the judgment as there being 2 points, the second of which my lady has described.
Yeah,
And I'll come back to that because the answer is going to be they did consider.
yeah.
And they did consider on the facts of the particular case what benefits might flow from
But
them.
well, you say that operational consequences are clearly a legitimate factor falling within other factors.
I do,
That's
but I
the short
do
point.
also say there was an error of principle in the first way, because when they're addressing how the principles work, particularly at 82 to 84, they do look as though they're restricting it.
I understand that, but I'm just trying to work out why
Why
it matters.
ultimately it went against them.
Why ultimately what their approach to terrorist activities impacts on their ultimate conclusion at 94.
Well, my lady, yes, but my submission is that by the time they've got to 94, you may be right that ultimately when they get to that part of it,
It's a separate point.
it's a separate point.
But I understand you're entitled to look at all the things you complain about.
Right.
But as I see it, at the end of the day, the nub finding
Is in
on
94.
the other factor point was that operational consequences and advantages of prescription was not a factor consistent with the policy.
Yeah, my lady, that's true, but one can't ignore the analysis which leads them.
No, I understand.
Which is that they seem to be taking the position that in principle you can only look at conduct which is terrorist in nature.
I've got some difficulty with your argument that you can look at other activities. Leave aside the policy now. Parliament has said that in certain circumstances, things are so bad, we've got to tackle the activities of other people by supporting and funding them. And when you're deciding to do that, you can look not just at the things that are so bad, you've got to step in. You can look at other things that are not so bad and which wouldn't justify stepping in. And it's hard to see perhaps why you should be able to take it into account non-qualifying, if I can put it that way, activities. You say escalation. I think what you're saying is look at the picture of the organisation as a whole. This isn't so bad, but it might get worse. Is that the nub of what you're saying? Not other activities full stop. It's other activities, if they indicate, are leading into the things that the Act is worried about.
My answer, if I may, goes like this. Point one, you don't get into this territory unless you satisfy the statutory precondition. So the organisation must be concerned in terrorism in one of the ways that Parliament has
Yes,
identified.
I accept that, yes.
Right? So you've got that base. Once you're there, what Parliament has done is to say the Secretary of State then has a discretion as to whether or not to prescribe. So that's a separate stage that has to be considered. The question then is other conduct, or other actions that sit below that, are they relevant in principle to the consideration of the exercise of that discretion? My submission in answer to that is that the answer to that must be plainly yes. And it must be plainly yes, A, because of escalation, the possibility of escalation, and not merely the possibility here, the fact and the assessment that this was on an upward trend. We saw, I took you through all that when we went through the facts. But secondly, because, as it were, the dividing line between what may fall within the concern within terrorism and not may be very thin. And I know the court asked me some questions about this earlier on, but you can go to the JTAC assessment and they put it on the basis of serious damage to property because they've got the 3 incidents which plainly establish that, and then you add to those Bryce Norton. But we also know that JTAC concluded that some of those had involved really quite serious assaults on people. And, by the way, there were a whole bunch of other facts that were of real interest when considering the way in which this organisation operated. See the underground manual. See the way in which they'd set themselves up as a structure. See the fact that it may be extremely difficult, and is likely to be extremely difficult in some circumstances if you're undertaking this sort of action, to distinguish between one thing and another.
You're trying to work out the nature of the organisation, which looks at all its activities in your submission, not just a series of disembodied acts.
Yes,
Yeah,
but recognising that Parliament has put the base precondition in there. You've got to be concerned in terrorism. You can have an argument. You could, in theory, have an argument. Queen and Gull. You could, in theory, have an argument about the compatibility of the legislative definition of terrorism. We're not here to do that. We're assuming that's all compatible. And so my submission is it would be not merely, well, it would be very, very strange to preclude the consideration at the discretionary stage of any action that did not strictly meet the definition
Of terrorist activity.
of terrorist
Yeah.
activity. That's the core point
Yeah.
we're on.
Yeah.
Can you actually take those into account? My submission is you plainly can. And that must have been what Parliament intended. I mean, I don't know whether they did this or not, but they appear, at least at some point in the judgment, to be conflating the actions defined in 1(2) of the legislation and the activities referred to in the policy. And that just doesn't work. If they're to be treated as the same, there's no indication they should be.
If an organisation was engaged in a great deal of non-terrorist activity and some terrorist activity, that might be a factor militating against prescription. But it would remain relevant. It would not. You'd have to decide which way it
For good or
pointed.
ill.
Yeah.
Relevance is,
But it can be for or against prescription.
yeah, relevance is neutral as to who it helps.
Yeah.
Yeah.
Yeah. And the question is, should it be shut out? And for all the reasons I was discussing with Lord Justice Lewis, we submit not. As to the third step, the policy ordinarily precluded the Secretary of State from considering operational consequences and advantages of prescription arising under the general law, subject to the unusually effective exception. That introduction, I've made my slightly sneering point to get those words into the policy, but we say in answer to that third step that none of that is evident on the face of the short and open textured policy. It would amount to a fundamental redrafting of the policy with all the problems that would entail of the court assuming the role of policymaker. You'd have to introduce the positive preclusion, and then you'd have to introduce and define the nature of the exception. And we submit in any event that the operational consequences and advantages of, and disadvantages, I would say, of proscription were perfectly obviously something which the Secretary of State was entitled to consider. Again, this is strict irrelevance on the divisional court's analysis. The body concerned is concerned in terrorism, and you're thinking, well, despite that, where do we go? What are the advantages? What are the disadvantages? You do, naturally, the sort of exercise that you saw being done by the CTP. Where do we get if we just prosecute, or we go for some of the other alternative measures that are referred to on the less intrusive? Where do we go with that? Indeed, less intrusive measures would seem to be closed out by this analysis, which would be even more bizarre. And you look at that and you weigh it up, you say, well, can we just do criminal offences and other types of order, or is there a benefit from doing it? And the benefit from doing it might be that you attack the organisation itself as an organisation. You look to degrade, what's the purpose of the legislation, how does it work, go back to ABJ and the Supreme Court, that. All of that is inherent in the nature of the exercise of the discretion and proper. And my respectful submission is not merely is this in principle relevant, but that you can see a pretty powerful case for saying that it would be a positive public law error to treat it as irrelevant. And we've seen that the Secretary of State had before her, I would say unashamedly had before her, the CTP analysis on the benefits and disbenefits of all of this. Unusually effective, is there a SOP that is implicit in all of this? Answer, there is no process of implication that allows you to get unusually effective in as an exception to a controversial primary rule. I respectfully submit. And by the way, if you're thinking about that, you would have as a matter of substance to think about what the nature of that exception is. And what they seem to be doing is to say, well, if it would be unusually effective, you can take into account the very thing which the primary rule tells you is irrelevant. And you'd have to work out what it means. I mean, there might be a perfectly coherent argument for saying that even if you redraft the policy in that way and you introduce unusually effective, see the counter-terrorism policing report, here's the case. Should fall within it anyway. But I put that in not quite as a jury point, but jolly nearly. My real point is a point of principle, is you simply cannot imply this sort of structure into the words of this policy. And indeed, when you take into account all of these points together and you then go back to the policy appended to the men's subs with its references to ECHR, or just the policy on the face of the document that we saw at the end of the supplementary bundle, one is left with the greatest respect to the divisional court, scratching your head quite hard to work out how it could possibly be that rules of that sophistication and constraint could possibly be imported into the policy. There's my lords, that might be
A very convenient moment.
I'm going to come back and deal with ECHR after lunch.
Yes, indeed. So on to proportionality. Clearly, you have your Article 17 point.
I do, which I will develop briefly.
I think I can speak on behalf of the court when I say that we understand the importance of margin of appreciation. We are familiar with the authorities. So up to you entirely how you use your remaining hour, but if I could just check with my lords and my ladies.
Very quickly,
So
just make sure you have the references.
focus on the facts, as it were, or as ever, subject to your Article 17 point.
Thank you.
Anything else? Thank you all. 2 o'clock. Thank you very much.